It is my pleasure to welcome you all to this inaugural Justice Kma Samdani lecture. We are very honored that Mrs. Samdani has traveled from Lahore with two of her daughters and other family members to join us here today. So let me thank you very much. We are also deeply honored that Justice Asif Saeed Khosa, former Chief Justice of Pakistan, has accepted our invitation to deliver this inaugural lecture. But before we start the proceedings, let me call upon Qari Azam Tariq Sahib to get us started with the recitation of the Quran. Thank you. Qazi Sahib.
السلام علیکم ورحمۃ اللہ. اعوذ باللہ من الشیطان الرجیم. بسم اللہ الرحمن الرحیم. وَلِلَّهِ مَا فِي السَّمَاوَاتِ وَمَا فِي الْأَرْضِ وَكَفَى بِاللَّهِ وَكِيلًا. إِن يَشَأْ يُذْهِبْكُمْ أَيُّهَا النَّاسُ وَيَأْتِ بِآخَرِينَ وَكَانَ اللَّهُ عَلَى ذَلِكَ قَدِيرًا. من كان يريد ثواب الدنيا فعند الله ثواب الدنيا والآخرة وكان الله سميعا بصيرا. يا أيها الذين آمنوا كونوا قوامين بالقسط شهداء لله ولو على أنفسكم أو الوالدين والأقربين إن يكن غنيا أو فقيرا فالله أولى بهما فلا تتبعوا الهوى أن تعدلوا وَإِن تَلْؤُوا أَوْ تُعْرِضُوا فَإِنَّ اللَّهَ كَانَ بِمَا تَعْمَلُونَ خَبِيرًا. ترجمہ. اللہ ہی کے لیے ہے جو کچھ آسمان میں اور زمین میں ہے اور اللہ ہی کارساز کافی ہے. اللہ چاہے تو اگر اے لوگو تمہیں اس دنیا سے لے جائے اور آپ کی جگہ دوسری قوم کو لے کر آئے، اور اللہ تبارک و تعالی ہر بات کو سننے اور جاننے والا ہے. جو شخص دنیا کی ثواب کی امید رکھتا ہو تو اسے جان لینا چاہیے کہ اللہ تبارک و تعالی کے ہاں دنیا اور آخرت دونوں کا ثواب ہے. اے ایمان والو، انصاف پر قائم رہو اور اللہ کے لیے گواہی دو. اگر آپ زبان موڑو گے یعنی غلط بیانی سے گواہی دو گے یا گواہی دینے سے اعراض کرو گے تو جان لینا کہ اللہ تبارک و تعالی جو کچھ تم کرتے ہو اس سے باخبر ہے. صدق اللہ العظیم.
Jazakallah khair. Thank you very much, Qari Azam Tariq Sahib. Ladies and gentlemen, I'll take a few minutes just to give you some background about this lecture series and about Justice Kma Samdani. This lecture series was conceived in interaction with colleagues at Samdani and Qureshi, where Justice Samdani was the founding partner, and the Safer Communities Foundation, with which Justice Samdani also had an association. Barrister Farooq Qureshi and Dr. Nudrat Piracha from the law firm, and Dr. Shoaib Sadal, the founder of Safer Communities Foundation, were all involved in these discussions. As someone who had worked with Samdani Sahab in the law firm, I was also invited by them to join these discussions. All of us had got to know Justice Samdani over many years. Although Samdani Sahab left this world in 2013, whenever we met since then, our conversations would not end without some reference or mention of Samdani Sahab. He left an indelible impression on all of us, an impression of deep love, respect, and above all, a commitment to truth and justice. Ladies and gentlemen, we live in times when denigration of our institutions and the people associated with them is sadly common. In these times, more than perhaps ever before, it is important that we celebrate those brave and noble souls who have made tremendous contributions to the institutions that they have served. Justice Samdani, through his high standards of morality and integrity, had made tremendous contributions to the judiciary and the legal profession. Humble as he was, he would no doubt say that he was simply doing his job, applying the law fairly and speaking truth to power for him was the norm, and therefore unremarkable. Today, as we reflect on Justice Samdani's life, we know that we cannot take these traits of character for granted. Khwaja Muhammad Ahmad Samdani was born in a middle-class family in Karimnagar, Hyderabad, Deccan in 1932. He received his early education from his native city, Hyderabad, where Urdu was the official language of the state. In many conversations, and indeed in many of his books, he lavishes praise on the educational standards of Hyderabad, Deccan, as the Nizams there gave great importance to education. Justice Samdani often made the point that all subjects can be taught in Urdu and would narrate how mathematics and natural sciences were indeed taught in Urdu at the Osmania University in Hyderabad. Soon after partition, his family moved to Rawalpindi and then to Peshawar, where Samdani Sahab taught for a while at the Islamia College, before joining the civil service in 1954. After a period of about 5 years in the civil service, he opted for the judiciary and was elevated to the Lahore High Court in 1972. For all of us who have interacted with Justice Samdani, his qualities as a human being stand out. He was humble, courteous, principled, sharp-witted, and respectful to all, from the tea boy in the office to the highest-ranking officials who he met. His love of poetry is well known and evidenced in his writings, where he makes copious references to them. He was very fond of Ghalib and Iqbal and would recite them extempore. I can say that all who met him were mesmerized. He commanded attention and respect, not by fear or bullying, but by his soft-spoken, sharp words of wisdom, delivered with verve, yet with humility. He engaged all in his company, from young to old. Given the topic of the lecture today, let me focus on some of the qualities of Justice Samdani as a judge. What stands out in Justice Samdani's conduct as a judge is that rare yet essential quality for a judge, namely to have moral courage. There are many instances on which Justice Samdani demonstrated this. But for most lawyers, I guess, Justice Samdani made his mark when he granted bail to the former Prime Minister Zulfikar Ali Bhutto, and later when he declined to take the oath under the Provisional Constitutional Order in 1981. His grant of bail to Mr. Bhutto was not due to any love for Bhutto or his politics, but because he believed that Mr. Bhutto had a good case for bail. Grant of bail to Mr. Bhutto was significant, as unlike judges who in important political cases often reserve judgment, Justice Samdani dictated the order for bail of Mr. Bhutto there and then in open court. He did so at a time when it was clear that the ruler of the day, General Ziaul Haq, did not want such an outcome. A few days later, Justice Samdani was transferred out of the Lahore High Court as Federal Secretary to Islamabad. This ensured that he would not handle the trial. Later, when he returned to the Lahore High Court, judges were asked to take a new oath under the 1981 Provisional Constitutional Order. Justice Samdani refused to take the oath. You will hear his views on the video that we will shortly play. He was very clear on the matter. Judges faced with taking a new oath had no option but to resign and thus absolve themselves of their oaths. As he says in his book, and I quote, "Without doing so, they cannot go either behind or beyond the Constitution. In other words, they cannot have their cake and eat it," unquote. In some ways, I think Justice Samdani was ahead of his times. While moral courage of judges has always been necessary, the advent of modern social media and explosion of public information and debate has underscored the need for judges to show moral courage, to do the right thing, rather than be swayed by populism. Moral courage is today the focus of discussion amongst many Chief Justices around the world. I work in international development, so I interact with them. And the need for judges to display moral courage is today linked by jurists and practitioners to the fundamental constitutional principles of the independence of judiciary and the rule of law. In an address to Commonwealth Magistrates and Judges Association Conference in Brisbane in 2018, Lord Burnett, who's the current Lord Chief Justice of England, said this. He said, "Institutions are only as effective as the individuals who operate them. An effective judiciary is one constituted of effective judges. The most obvious means judges, that obviously means judges who are well qualified and appointed on merit. But it means more than that. A judge with these essential characteristics is not necessarily a good judge if he or she is not willing, when necessary, to make difficult decisions which upset powerful people and may be unpopular. A good judge will not let ambition influence the outcome of a case or play to the crowd in the expectation of praise. A good judge must demonstrate good character beyond the sense of an absence of questionable behavior. He or she must be capable of showing moral courage when difficult decisions arise." Ladies and gentlemen, the exercise of moral courage in the face of a military regime, I think all of you would agree, is in a very different league from what Lord Burnett and modern jurists refer to. It is one thing to exercise moral courage in a functioning democracy, but quite another to stand up to a military dictator. Some of you may recall the book Breaking the Curfew, written by Emma Duncan. In that book, she mentions Justice Samdani, and she records a very frustrating conversation with the then Chief Justice of the Lahore High Court, who had justified functioning of the judiciary under martial law. Emma Duncan, after having this frustrating conversation with the then Chief Justice, reflects on her frustration and anger, and she says, and I quote, "It was silly to be angry because the man had been to Lincoln's Inn and should have known better. Nobody in particular is to be blamed for subversion of laws and constitutions and systems, and for not standing up to people who take them into their own hands. The odd people are those like Mr. Samdani, who had refused to take his oath. I was ashamed of my self-righteousness. It was a luxury born not out of personal righteousness, but of the knowledge that where I come from, there were very few occasions in which somebody like me would have to choose between my conscience and my comfort. I would probably never have to know the bad news. Most of us will not be tested in this way, and like Emma Duncan, we may never know the bad news of our moral mettle. I believe that Justice Samdani's strong faith was the foundation of his moral courage. It is indeed not surprising that the late Justice Shafi Rahman Sahib has written a tribute to Justice Kma Samdani, in which he calls him the Sufi judge of Pakistan. I personally had the pleasure to be invited by Justice Kma Samdani to accompany him and his family members on a visit to Sufi Barkat of Salarwala, near Samundri in Faisalabad. At the end of that memorable visit, Sufi Barkat Sahib turned to me and while pointing to Samdani Sahib, said, "Ye Mard Momin hai." As a student of law, I enjoyed the movie A Man for All Seasons. Many of you, I'm sure, have watched it. It is a movie on the stance taken by Sir Thomas More then against Henry VIII, where Sir Thomas More, as Chancellor of England, refused to take the oath, acknowledging the king as the head of the church, and he was executed for his refusal. I believe that the stance taken by Justice Samdani was no less courageous in meting out justice on merit and speaking truth to power during a military regime. Though I must note that unlike Thomas More in the movie, Justice Samdani was much, much luckier. He had a wife who understood and supported him and his cause. So for me, Justice Samdani was not just Pakistan's man for all seasons, but he was also, as confirmed by Sufi Barkat, Mard Momin. And may Allah grant him maghfirah and a high place in Jannah. Ameen. Justice Samdani, through his example, set high standards of judicial conduct and in upholding the rule of law. We hope that through this lecture series, dedicated in his name, we can make a humble contribution to strengthening the rule of law and the cause of justice in our own country. May I request that the video be played now? Thank you.
इसियों के तहत तलब उठाने का आज जो चर्चा ना उठाने का जो इतना चर्चा सुन रहे हैं, तो समदानी साहब ने 1981 में इसियों के तहत तलब ना उठा के एक नई दौर को एक हवा दी और उन्होंने कहा कि ऐसा नहीं करेंगे और उन्होंने ऐसा नहीं किया।
नेचर मुझे ये यकीन था कि अगर मैं कुछ भी करूँगी कभी नहीं करेंगे और मैं पर्सनली ये नहीं चाहती ये पुश हालांकि बहुत से ऐसे नाम लेना नहीं चाहती, बहुत से ऐसे फ्रेंड्स ऐसे कपल जो मुझे समझा रहे कि देखो तुम लोगों को हमें पता है तुम लोगों का तो सैलरी पे ही गुजारा है, ठीक और हमारे माशाल्लाह 5 बच्चे हैं। अब आप सोचें कि बड़ी बच्ची जो बड़ी से लेके छोटे बच्चे 2 साल तक का बच्चा और हमारा मंथली उस पे गुजारा था सैलरी, और तो वो यही कहते थे कि तुम लोग कैसे रहोगे। मैंने कहा सुना तो है कुरान बहुत बड़ा भी है कि राज़िक़ अल्लाह है, तो फिर वो राज़िक़ कहाँ जाएगा। ठीक क्या वो है तो क्या हम तो देखो तुम्हारी गाड़ी जाएगी, तो मैंने कहा सो व्हाट, गाड़ी चली जाएगी ना, ये वैगन के बसेस तो हैं और मेरे बच्चे अवाम किस लिहाज से मुख्तलिफ, क्या वो मुख्तलिफ है। उनका बाप सर्विस कर रहा है जी तो सर्विस का मतलब ये है कि समदानी अपना ज़मीर बेचे मगर गाड़ी जरूर रखे। ठीक मैं तो कभी नहीं चाहूँगा। ओहो वेरी गुड। आप इसके लिए आप पूछ सकते हैं कभी, और मैंने कहा इसकी फिक्र मत करना कि मुझे कोई तकलीफ हो, अगर हमें भूखा भी रहना पड़ा तो हम रहेंगे।
बहुत अच्छी आदत। और इस सिलसिले में मैं ये कहना चाहूँगा कि میں نے اپنی کتاب میں آپ کے لیے لایا
بہت شکریہ.
تو آپ پڑھ لیجیے.
جی
تو اس میں اس بات کو اکنالج کیا کہ آڑے واڑے میں انہوں نے ہمیشہ میرا ساتھ دیا اور اس بات کا اعتراف بھی ہے اور اس کتاب کو میں نے منصوب کے نام کیا. تب یہ ہوا تھا کہ جتنے وکلا تھے سب ہمارے گھر پہ جمع ہو گئے اور ہمارے ساتھ ہمدردی کا اظہار کیا.
ہمدردی کیوں؟
ہمدردی کا اظہار کیا تھا بلکہ یہ تھا کہ ہر شخص نے اپنی بساط کے مطابق ہماری مدد کرنے کی بھی آفر کی.
اچھا.
لیکن انسٹیٹیوشنل لیول پر یعنی ادارے کے لیول پر کوئی کام نہیں کیا. جو آج ہو رہا ہے وہ اس وقت نہیں کیا. اس وقت جو جنسیوں کے تحت ججز کے سامنے پیش ہوتے رہے اور انہوں نے بالکل کوئی احتجاج نہیں کیا. 81 سے لے کر کے اب تک جو ہے 81 سے لے کر کے اب تک کتنے 26 سال.
جی ہاں
27
ٹھیک.
تو سمجھے کہ 27 سال
تو ایسا مارچی میں کیوں ہوتا ہے؟
ہاں اچھا مارچ قوم آگے بڑھنے تو یہ ہوا تھا کہ انہوں نے ادارے کے لیول پر اچھا وکلا نے جو نہیں احتجاج کیا تو میرے خیال سے اس زمانے کے وکلا کو اس بات کا احساس نہیں تھا. ذات طور پر انہوں نے بہت کچھ آفر کیا لیکن جو کام اس وقت ہو رہا ہے وہ نہیں ہوا تھا. شاید اس لیے کہ اب جنریشن جس آئین کی پاسداری کا حلف اٹھاتے ہیں تو جج بنتے ہیں.
صحیح.
اور اس کے بعد میں آئین کی نفی ہوتی ہے تو کہتے ہیں ٹھیک ہو. وکالت کا لائسنس حاصل کرنے کے لیے سپریم کورٹ میں درخواست دی. تو ایک صاحب نے مجھے دیکھ لیا سپریم کورٹ میں مجھے بلا لیا واقعیت میں نام نہیں چاہتا کہ
اچھا.
تو کہنے لگے سمدانی صاحب یہ عورتیں اوت کی جمع کہا کہ یہ عورتیں تو ہی رہتی ہیں آپ نے یعنی ان کے نزدیک کوئی اہمیت نہیں. یعنی جس قوم کے ججز کا یہ رویہ ہو کہ وہ حلف کو کوئی اہمیت نہیں. آپ حلف اٹھاتے ہیں اس سے سالم موت اور سالم موت آپ کی ہوتی ہی رہتی. تو پھر آپ کیا امید رکھتے ہیں؟ تو ان کے نزدیک اکثر وہ لوگ جو کسی کے تحت حلف اٹھاتے ہیں ان کے نزدیک حلف کی کوئی اہمیت نہیں. وہ کسی کے بھی وفادار نہیں ہے. جو آئین کا وفادار نہیں ہے وہ جج جو سپیریئر جوڈیشری کے جو جج ہیں چاہے ہائی کورٹ کا جج یا سپریم کورٹ کا جج ہے وہ کسی ٹیمپرل اتھارٹی ایز اگینسٹ اسپرچوئل کسی ٹیمپرل اتھارٹی کو آنسریبل نہیں ہوتا. وہ کسی کو آنسریبل نہیں. اور یہ بڑا فرق گورنمنٹ جو ہے تو گورنمنٹ آنسریبل اور جو جج ہوتا ہے چاہے وہ ہائی کورٹ کا ہو یا سپریم کورٹ کا ہو وہ یا خدا کو جواب دے یا اپنی زمین کو جواب کسی اور کو جواب دے بالکل نہیں. اللہ کی عدالت. اسی لیے گورنمنٹ سرونٹ میں اور جج میں زمین آسمان کا فرق ہے. یہ ہماری قوم کو سمجھ لینا چاہیے. ڈیمانڈ ایسی ہے کہ عدلیہ کے ساتھ جو کچھ صدر پرویز مشرف نے 3 نومبر کو کیا وہ غلطی تھی اور اس غلطی کا ازالہ جتنی جلدی ہو جائے اچھا. اور اس لیے یہ شور ہے کہ اس غلطی کا ازالہ ہو جانا چاہیے. یعنی 3 نومبر پوزیشن بحال ہو جائیں.
تو یہ کیا بہت آسان کام ہے؟
جی
یہ آسان کام ہے.
جی ہاں یہ کام بہت آسان ہے کہ جو کام غلط ہے وہ غلط.
ٹھیک.
جن ججز نے پی سی او کے تحت نہیں لیا وہ میری نظر میں ابھی جج.
اچھا
دیکھیے جج وہ ہے میری نظر میں جج وہ ہے جو آئین کی پاسداری کرے. اگر یہ ججز یا ان میں سے کچھ ایسے ہیں جو آئین پر حلف اٹھائے ہوئے ہیں تو ان کو تو وہ تو بحال ہو جائیں. اچھا یہ ذرا کمپلیکیٹڈ کوسچن ہے لیکن یہ ہے کہ 3 نومبر پوزیشن تو ریسٹور ہو جانی چاہیے. اس کے بعد یہ دیکھا جانا چاہیے کہ کون جج ہے اور کون جج نہیں. میرے نزدیک یہ میری ذاتی رائے جج وہی जज कहलाने का मतलब है जो आईन पासदारी के हलफ तहत काम कर रहा हो, जिसने आईन पासदारी का हलफ नहीं उठाया या उठाने के बाद उसको तोड़ दिया, वो जज नहीं, मेरे नहीं। और आईन ही वो किताब है जिससे सारी कौम, सारी हुकूमत और सारा माशरा कंट्रोल होता है, और आईन पासदारी बहुत जरूरी है। ठीक। तो अगर अब ये जो प्री नवंबर पोजीशन आएगी, इसमें भी ये मसला है कि क्या वो जजेस जिन्होंने इस इश्यू के तहत हलफ नहीं उठाया, तो क्या उन्होंने 1999 इश्यू के तहत हलफ उठाया कि नहीं उठाया? 1999 में जब
तब इश्यू के तहत हलफ उठाया था, तो फिर क्या होगा?
तो फिर ये होगा कि मेरे नजदीक जज वही है जो आईन का हलफ।
ठीक।
नहीं
सही।
और ऐन मुमकिन है कि उसके बाद में ये आईन का हलफ ले ले।
सही। ठीक।
I would like to share only a gist of what this man fame was like as a father. Baba was in his 50s when he started his professional life new by starting the law practice. Life suddenly became extremely hectic for him. Although based in Lahore, he could not appear in the Lahore High Court as counsel, which meant that he was traveling all over the country a little too frequently for his own good. Neither the hard work nor the tedious life made him fall short of his duty as a father. During those years, it was not uncommon for him to be home only for a few hours before returning to the airport. But he would utilize even that time to be with us for what appeared to be a fun chit-chat session on the surface, but was in fact the most valuable time dedicated to our upbringing.
We were very lucky to grow up in a house where Baba really drilled into us the importance of education for the sake of knowledge, not for grades, not for what job it could get us, but for knowledge, because that is the obligation that we must all meet. So for me, I think there are many inspiring aspects of his tarbiyat, but for me, I would say that is the most, the one that most stays with me.
Let me thank Samdani and Qureshi for putting together that video at a very short notice. I hope that this video has given you all a taste of Samdani Saab's personality. I would especially like to thank Justice Samdani's daughters who recorded brief messages at the end of the video. This certainly, I think, helps us to understand Justice Samdani as a man, as a person, and in the context. Let me now call upon Dr. Shoaib Sadal, the founder of the Safer Communities Foundation, to say a few words. Dr. Sadal, I'm sure, is indeed known to all of you through his distinguished career. Dr. Sadal has held many distinguished positions. Belonging to the Police Service of Pakistan, he has risen to the rank of Inspector General of Police in 2 of the provinces, Balochistan and Sindh. He has also headed the Intelligence Bureau, which is Pakistan's premier civilian intelligence agency. He has contributed to police reforms, including as Director General of the National Police Bureau and as a consultant to the National Reconstruction Bureau. His views on police reform has been sought by policymakers and the judiciary alike. Consistent with our theme of speaking truth to power, Dr. Sadal is known for expressing his frank views and standing for what he considers to be the truth. During his stint as DIG Karachi, he led the cleaning up of Karachi in the 90s. He is well respected outside the country too, and has served as an expert to several international organizations, including the United Nations Office of Drugs and Crime in Vienna. Dr. Sadal is also International Director for the Asia Crime Prevention Foundation in Tokyo. Beyond policing, Dr. Sadal's term as the Federal Tax Ombudsman is a memorable one, with record disposal cases and recovery of rebates. Dr. Sadal is currently the one-man commission on minorities at the Supreme Court of Pakistan. It is my pleasure to request Dr. Saab to say a few words. Thank you, Dr. Sadal. Please.
Justice Khosa Saab, Mrs. Justice Khosa, ladies and gentlemen, we are really honored, not only because of the man we are gathered here to pay tribute to, but also the keynote speaker of today. You know, you are all well aware of the metal Justice Khosa Saab is made of. I'm not going to go into, any lengthy speech, because I'm grateful to Hamid Saab. He has covered lot of ground, but I will take few minutes only to highlight the sort of person Samdani Sahab was. Leaving aside my own interaction with him, I will just read through a couple of paragraphs of his article, which he titled Confrontation. So I quote, "It was the 1st of April 1980. I had just returned, and I means Samdani Sahab, from my official tour of Australia and Japan. I was then the Secretary to the Government of Pakistan in the Ministry of Law and Justice. I had learnt in Japan that the impending elections in Pakistan had been cancelled, and cancelled for good, despite all the expenses incurred in connection therewith. At any rate, I had to attend the meeting called by the CMLA, as I was already in Pakistan. In fact, all the cabinet ministers, some of them serving generals, and all the federal secretaries present in Islamabad attended the meeting. Having returned home only a day earlier, I did not know the agenda even. Later I learnt that in fact nobody knew the agenda. The CMLA was presiding over the meeting. Agenda or no agenda. He started the meeting by asserting that rightly or wrongly he was the president, and as such his order, right or wrong, should be carried out without demur. It was obvious that he was referring to perhaps those secretaries who had refused to oblige him. He said, I would like to strip the secretaries naked and hang them upside down. This was a bit too much to swallow. When he was through with this harangue, I waited for a while, hoping that one of the senior secretaries would respond to the unparliamentary language. For one thing, I was not a secretary. I was above that level, being a High Court judge, only performing the functions of a secretary. But when no secretary showed the courage to utter a word of protest, I had to speak up. So I told the CMLA that there was a word of difference between being president rightly or wrongly and being president wrongly. The latter position was like being on a weak wicket, which weakens enough to be realized. However, I concluded my long response by saying that I would also like to see and this is the courage of the man. He said, I would also like to see a couple of generals hung by their ankles with their pants off. And the rest of it, obviously this left the entire gathering stunned. When I was through, the general said, maintaining his cool, he would like to see me alone at the end of the meeting, which then proceeded normally as if nothing had happened. At the end of the meeting, tea and refreshments were served to the participants. Some senior CSP officers, in good faith, tried to persuade me, as I had also been a CSP officer, to apologize. However, I politely declined. After the tea the CMLA called me in chamber and wanted the resolution of the situation created by me. I said it was simple. I asked him to reconvene the meeting and apologize for what he had said. I said I was also willing to apologize. To this suggestion, he did not agree. So I refused to apologize. Consequently, our meeting ended in an impasse and we parted company. 3 months later, I was sent back to my own High Court. That is the Lahore High Court. It was like home coming to me. After more than 2 years in the federal government. So, ladies and gentlemen, I stop. I thought this was perhaps the most powerful message that I got out of that book, which is, I believe, with all of you, because it has been given individually. I would request all of you to go through it. And in the process, hopefully, if not all of us, at least some of us, should try to pick up some courage to say no to the persons in authority, whosoever they are, and especially those who deal with the matters of life and death and who deliver justice. Thank you very much.
Thank you very much, Dr. Shoaib Sadal Saab. I think this is probably one of the most inspirational anecdotes from Samdani Saab's life. I think it affects us all. And, I used to work a lot on Pakistan in international development. And to friends, I would often comment that I'm very sad to see the growth of what I call the Marasi culture, where we find it so difficult to disagree in the face of, frankly, some quite unacceptable views, which are often stated. I hope that this incident you've narrated, Sadal Saab, can inspire us all to stand up for what is right and not simply to just bow down to authority, because that is sadly what our culture is. I would now like to request Dr. Nudrat Paracha to say a few words. Nudrat works with Samdani and Qureshi in the law firm which Samdani Saab was founding partner of. She is currently a partner there, and I'm very pleased to introduce Nudrat because I've known her for a long time. I've seen her grow, and she holds the distinction of being the first Pakistani woman to have been awarded a doctorate in juridical science, SJD, from George Washington University. And as I'm sure many of you know, SJD is the highest degree you can get in law in the USA. Having worked as a professional for the last 20 years at the firm, at a young age, she has made her mark by handling several international arbitration matters, including those before the International Chamber of Commerce and ICSID, which is the International Center for the Settlement of International Disputes. She is the only woman in Pakistan to have served as an ICSID annulment committee member in Washington, D.C. Her book, if you have not seen it, you should, toward uniformly accepted principles for interpreting MFN clauses and striking a balance, has been extremely well received by the academic community and the practitioners of international arbitration. Nusrat is a UK qualified solicitor, advocate, and also a fellow of the Chartered Institute of Arbitrators of the UK. She has served on the 12-member committee formed by the government of Pakistan to advise on investment arbitrations, and the 8-member committee formed for advising on international law. So without much ado, Nusrat, please.
Bismillahirrahmanirrahim. Thank you, Amit Saab, for that very generous introduction. It is my pleasure to be here amongst all of you and to have the honor to speak about our dear Justice Samdani. We at Samdani and Qureshi had the honor and good fortune of having Justice Samdani as our mentor and as a friend. He served as a civil servant, a judge, and an advocate, which gave him a unique perspective as to what has gone wrong and what needs to give. This memorial lecture is a reminder that his life exemplifies, at the very least, that character, integrity, honor, and staying true to yourself outlives a person. He inspired and touched the lives of those who came in contact with him. Today I will touch upon very briefly what his life stood for and what lessons he left for the legal fraternity through his conduct and his advice. Summing up his life and his personality is like trying to measure the ocean. How does one measure the ocean? Or a person for that matter. Justice Samdani once said that his standards for measuring a person had changed over time. He said, I came to the conclusion that closeness to Allah is the absolute measure of greatness. Should that not be possible to gauge? Personal character is a valid measure. Should that prove improbable to judge? You are left only with knowledge, which by itself is not a bad indicator of a man's personality. Justice Samdani would measure equally on any one of these measures, be it love for Allah, knowledge, or the strength of his character. As the senior-most partner at the firm, he believed in appreciating the integrity of his juniors and in encouraging them. He never expected his colleagues to mold their views according to his opinions, for he believed that this would amount to dishonesty on part of the junior and foolishness on part of the senior. As a senior, he displayed intellectual maturity and would take on board opposite and different views. He would say there is no such thing as the last word in an intellectual debate. He was always mindful and respectful of others regardless of their title and position. As disregarding self-respect of others and tolerating insult to one's own self, in his view, made us good subordinates and bad bosses. He was keenly aware of the responsibility of mentors, as more often than not, professional competence in Pakistan, he said, is the result of the training that an apprentice lawyer gets from his senior. As a professional, he taught us the importance of keeping promises, being punctual, avoiding unnecessary arguments, expressing our views, behaving responsibly, being trustful and honest, considerate generally and in particular in our selection of words, and being courteous yet firm. He also taught us respect of the law and the Constitution, being just and fair, never to compromise on our principles, serve the people, strive for perfection, not to forget one's origins regardless of attainments in life, and act conscientiously and to the best of one's abilities. He considers character as the deciding factor in the selection of lawyers and appreciated competent and sincere advice that he had received from the bar as a judge. He admitted to having learned a great deal from the lawyers' fraternity. His quest for learning inspired us he would say that the process of learning should not be allowed to end and shall continue till one's grave. In grooming us as lawyers, he taught us that our duty as the counsel is to present client's case in the best possible light. Of course, this is without contaminating it with misstatements of fact or law. Misleading the court is against professional ethics, he would say. After his bypass, he stopped appearing before the courts as counsel, owing to the attendant stress originating from court practices in vogue at the time. In particular, practice which bred uncertainty due to adjournments and last-minute publication of cause lists by superior courts. He then focused more on consultation and arbitration work. In keeping with today's topic, I now turn to Justice Samdani as a judge. His life exemplified what a judge should be and what duties burden the judge's vocation. He, as Hamid Saab has pointed out, was a marde moment first and a marde moment last. While we have all heard a judge should be a gentleman first and a gentleman last, if he also knows the law, so much better. Justice Samdani was of the view that expression marde moment embraced all the attributes of the gentleman of the English society and a great deal more. So a judge has to be a marde moment first and a marde moment last. He deemed himself accountable only to Allah and his own conscience. He followed the dictates of law at the expense of suppressing his own personal views. He was not an enforcer of his personal predilections in matters before him. His decisions were based on objective, non-biased, and not on latent, subconscious preferences. He would say that judges are as much bound by the law as anybody else. Some judges consider themselves above the law. This is a mistake. The sooner the judges correct themselves, the better. Law has to be respected in law and in letter and spirit. There is no room for expediency. Society pays them to put the correct legal and constitutional position of every situation before it without fear or favor, so that the public may know whether every institution, including the government, is performing its functions in the way it should. Running the government or salvaging the country is not the judiciary's business. Everyone should mind one's own business. He followed the framework for neutral, objective decision-making rather than adopting methods that directed him to the results he preferred. Those who witnessed his demeanor would testify that his even-handed demeanor projected to the parties and the public fairness and impartiality. He conducted himself and his court in a way that inspired public confidence in the process by which the decision was reached. He maintained his independence and integrity, come what may. He did so with courage. His conduct demonstrated that just legal acumen is not enough for doing justice. Courage to render an honest decision is a necessary requirement. He would say that a judge without courage is no judge. Such courage comes from faith in Allah and a sense of honor and self-respect. Neither fear nor hope of favor could deter him from what was right. He considered such considerations to be unpardonable. In disapproving such conduct, he once said that some judges would have no qualms of conscience trampling over the rights of the people only to remain on the right side of the government. What a pity. Before the British left this country, one of them remarked that of all the institutions that they were leaving behind, the judiciary was the one which could never come to harm except from the inside. He was broad-minded enough to accept valid arguments against his own views and said it does not become judges to be egoistic. Humility should be the badge of this tribe. He believed in justice for all, whether or not someone deserved it. He believed that each for he believed that even for one day of wrongful detention of a person, the entire judiciary, nay, the entire society is responsible. He established through his conduct that judges neither have sword nor wealth in their hands, but they have pen to write verdicts, which is more powerful than a sword. If judges decide according to the Quran and Sunnah, every society will give them honor and respect. While he undoubtedly accepted the Supreme Court as the final court, he did not consider it infallible. In Justice Samdani's view, there are three impediments to achieving the goal of judicial independence. First, the possibility of blackmail on account of one's antecedents. Second, propensity to seek favors. And third, the lack of immunity to inducement. In superior court judges, he thought it crucial for them to have morality, intellectual integrity, professional competence, the courage of conviction, originality and vision of the future of society as a selection criteria rather than seniority. He would say that one who aspires to a judicial office and exercises influence for such appointment should be ignored for such position. Justice Samdani aspired for judges to be courteous, not to act with a predisposition, or assume the role of opposite counsel, that too without hearing the counsel. Samdani Sahib considered that the judiciary, being master of the process, could play a proactive role in ensuring expeditious dispensation of justice despite all hurdles. To Samdani Sahib's mind, subjugation of the judiciary to the executive was unacceptable. Judges should not give their verdicts to oblige rulers, but to fulfill the principles of justice according to Quran and Sunnah. He cautioned that only an immature and dishonest executive would have a pliable judiciary. He was a strong believer in institutions observing their constitutional limits and opined that a system can only work effectively if every person involved knows the limitations of his position and also his relative position vis-a-vis other persons. Nobody seems to be bothered when the guardians of law themselves break the law. He taught us to live with honor. As a citizen, he lived with honor, for to him that distinguished man from animal. As explained, that what really counts, he explained what really counts in our profession, whether for judge or an advocate, is integrity. Once they lose integrity, they lose everything. To sum up, Justice Samdani's life teaches us to discharge obligations rather than insist on rights, that duties to Allah are important, but duties to mankind are more important, the virtue of humility with dignity, the importance of austerity, that ostentation is cheap, that austerity is more impressive than ostentation. He had high hopes for this generation, and once said, "My generation made a lot of mistakes. The next generation is adopting them as norms. It will be a great tragedy if they do not start the process of rectification in time." I would want to leave you with these final words of Justice Samdani, which have dictated the trajectory of my life in sketching out reforms to revolutionize the justice system of Pakistan. Justice Samdani said that some of us individually are certainly free from these two maladies, short-sightedness and collective immaturity, but they are scattered and therefore ineffective. Can this situation be rectified? Can those with intellectual maturity and vision put their sources together, become effective, and reform the nation? It is certainly difficult but not impossible. Therefore, we should not flinch from making an effort. Thank you.
Thank you very much, Nusrat. I think your address really lays out some of the essential values necessary for an independent judiciary. Judges, honorable judges, distinguished guests, ladies and gentlemen, it is now my distinct pleasure to introduce our guest speaker, our first Justice Kma Samdani Memorial Lecture speaker, Justice Asif Khosa, who, as all of you know, has had a very distinguished career. He was the 26th Chief Justice of Pakistan from 18th of January 2019 to 20th of December 2009. I've got this, the dates don't make sense. I've got something wrong here. But anyway, he was a distinguished judge, and he belongs to, of course, the Baloch tribe. Justice Khosa is a barrister of Lincoln's Inn with a master's in law from Queen's College, Cambridge. He has penned many important judgments that will be cited for decades to come. His expertise in criminal law in particular and constitutional law is very well known. Justice Khosa has delivered some brave judgments that do not pander to populism. As we celebrate Justice Samdani's contributions to Pakistan's judiciary, I'm very pleased to say that Justice Khosa also has the distinction of refusing to take an oath under military rule. When General Musharraf declared a state of emergency in November 2007, suspending the Constitution and demanded the judges of the superior judiciary to retake their oaths under the Provisional Constitutional Order, Justice Khosa, like the then Chief Justice Iftikhar Muhammad Chaudhry and many other senior judges, refused to retake the oath. They were suspended from their duties. On 18th of August 2008, he was restored to his prior position as High Court Justice as a result of a lawyers' movement to restore the deposed judges. So to paraphrase Emma Duncan, Justice Khosa may be the only one in this room who knows that there is no bad news with respect to his moral mettle. It is an immense honor for us all that Justice Khosa has been internationally recognized for his contributions to independence of the judiciary, court administration, and judicial education. Justice Khosa was earlier this year selected to receive the Justice Excellence Award of 2022 by the Institute for Justice Excellence in the Netherlands. The selection was made by, please, thank you. The selection was made by a committee of Chief Justices from all over the world, including those from the USA, UK, Germany, and Spain. Amongst the achievements cited and taken into account by the committee were the establishment by Justice Khosa of a research center at the Supreme Court with access to almost all legal research databases in the world, the launch of a mobile application for public to track the proceedings in the Supreme Court, and his dealing with politically and religiously sensitive cases on the basis of merit. We are honored, Justice Khosa Sahib, that you are honoring us all by agreeing to deliver the first Justice Kma Samdani Memorial Lecture. Your topic, the independence of the judiciary, the final frontier, is a pertinent subject in today's Pakistan. So without much ado, sir, I invite you to deliver your lecture. Thank you.
Honorable Chief Justice Muhammad Noor Maskanzai of the Honorable Federal Shariat Court, who has recently rendered a landmark judgment abolishing riba from this Islamic Republic of Pakistan. Honorable Justice Chauhan, I see, retired Honorable Justice. We have served together in the Lahore High Court. Dr. Sadal, the members of his foundation and the organizers of this lecture, very distinguished civil servants, retired civil servants present in the room who have given the best years of their lives for public service in this country. Some respectable persons from the media, very respectable journalists I see here, distinguished guests, ladies and gentlemen. After watching the movie about Justice Samdani, I was reminded of many things, and I'll just briefly refer to some of them. I had the distinction of appearing before Justice Samdani. I was a very young lawyer of the Lahore High Court, and Justice Samdani at that time was a senior judge of the Lahore High Court. I did my best, went home, and after so many years, Mrs. Samdani, present here today, has told me something about that day which has made my day, my month and my year. Mrs. Samdani has just told me before the commencement of these proceedings that after, as a young lawyer, I had argued before Justice Samdani, Justice Samdani had gone home and told his lady wife that this young man who appeared before me today is going to go far. And that was, so I'm elated by these words. He was very gracious, he was very kind, and I'm grateful to Begum Sahiba for telling me this, because this will keep me happy for the rest of my life, that a person of his stature saw some spark in me right in the early ages. The other thing that I remember is that when Justice Samdani granted bail to Mr. Zulfikar Ali Bhutto in such trying times, we as young lawyers immediately took fancy of such a brave judge, and ever since he has been our hero. The third thing was the incident which Ms. Dr. Saddle told about, the meeting with General Ziaul Haq, in which, as Federal Law Secretary, Justice Samdani had said something, and we as judges of the Lahore High Court had come to know of that. And as far as I remember, he must be knowing better, but the words which came to us were that General Zia said that I want to hang a few judges because they don't let us work. But Justice Samdani retorted and said, why don't we hang a few generals who don't let judges work? The next thing that came to my mind, and it was mentioned by Begum Sahiba in her in the video clip, that Justice Samdani did not take oath and came back home. He had 5 children who were to be supported along with the lady wife, and apparently there were no other means of income except his salary, which was gone. I also have some parallel in that regard, that when on 3rd of November 2007 I refused to take oath under the PCO of General Musharraf and came back home, I had only 14,000 rupees in my bank, and I had one young lady, young wife, and even younger daughters to take care of. But as was said by Begum Sahiba in her video clip, that Wallahu Khairur Raziqeen, Allah Ta'ala khud hi bandobast karta. So these were the initial thoughts that I said that I'll share before I go to my written discourse. And I'm grateful to the foundation for choosing me to be the first lecturer in this series of Kma Samdani Memorial Lecture. And it's a great privilege for me to be here today, being the first lecturer in the series. Justice Kma Samdani is and shall always remain a legend in the judicial and legal fraternity in this country. His full name was Justice Khaja Muhammad Ahmad Samdani, and according to his autobiography titled Jaiza, published in the year 2004 by Sange-Meal Publications, Lahore, he was born on May 13, 1932. And it is not a coincidence that today is May 13, 2022. It is his birthday today. May his soul rest in eternal peace. So he was born on May 13, 1932 in District Karimnagar in the Indian state of Hyderabad, Deccan. He breathed his last on April 11, 2013. He was born in a middle-class family. His autobiography reveals in some detail different phases and challenges in his life and how he coped with them. In his childhood, the main emphasis of his family was on character building. As a student and a young man, he did not like being bullied or browbeaten. This is in his book. So it's very ominous. This is how the young man was growing. He did not like being bullied or browbeaten. As a civil servant, he was devoted to public service. As a judge, his commitment to the cause of justice was unwavering, and his dedication and honesty of purpose were exemplary. As a judicial officer, he had his heart in the right place, and he was absolutely clear about what a judge ought to do and also what he ought not to do. Later in his life, the circumstances compelled him to become a lawyer, and even in that capacity, he displayed the highest standards of integrity, probity, and ability. Thank you. Thank you. Even as a consultant to different international bodies, thank you so much. Ye utha le. Thank you very much. Even as a consultant to different international bodies, he was an embodiment of professionalism, commitment, and dedication. Justice Samdani's life was a constant struggle, and he waded through it with his head high and chin up. The most revered and respected aspect of his judicial career was his independence. It is in that backdrop that the subject chosen by me for today's talk is Independence of Judiciary, the Final Frontier. I had written a paper on this subject a few years ago and have improved it for the present discourse. By way of an opening statement, I would like to observe that independence of judiciary is not an end in itself, but it is only a means to the end. And the end, for sure, is impartiality of judiciary. For diverse reasons that all of us can conceive, an otherwise independent judiciary may still not be impartial, and that is why mere achievement of independence of judiciary may not be good enough if the real objective of impartiality still remains an illusion. I may therefore emphasize at the outset that for any meaningful understanding of the issue, it is imperative to realize and appreciate on a philosophical level that independence of judiciary is not the ultimate milestone to be crossed or the final target to be achieved, but it is an ongoing effort in which different targets are to be set and achieved, different stages are to be crossed, and different levels are to be attained till we achieve the ultimate objective of impartiality of judiciary. Stage one in this context is identifying the bottlenecks and removing them by suitably interpreting various constitutional and statutory provisions, statutory instruments, in order to pave the way for achieving independence of the judiciary. Stage 2 is consolidation and strengthening of independence of judiciary through bringing about and reinforcing the necessary milieu for the same. Stage 3 is ensuring such a perception of the judiciary that the general public and the society at large feel persuaded to support its independence for their own benefit. And the fourth and the final stage of independence is that which I call the final frontier. I can understand your curiosity about this fourth stage, but kindly wait for a few minutes till I come to the final frontier in the later part of this discourse, after some brief comments about the earlier three stages. Before framing of a constitution of our homeland, the founding fathers had resolved in the Objectives Resolution of 1949 to frame a constitution which establishes an order wherein, amongst other ideals, the independence of the judiciary shall be fully secured. The said aspiration of the founding fathers now stands translated into the main body of the Constitution of Pakistan and forms a substantive part of the same. On the basis of that one sentence of the Constitution, I, as a young practicing lawyer, had built a whole thesis in the year 1994 and had written a detailed article titled Independence of Judiciary, a Constitutional Challenge, highlighting therein the loopholes in different provisions of the Constitution and how such loopholes were exploited by their misuse by those interested in thwarting independence of judiciary. I had humbly suggested in some detail the ways through which those loopholes could be plugged through the means of interpretation of the Constitution. That article of mine was published in PLD 1994 Journal, page 101, and the same was also read by me as a paper at a seminar organized by the Supreme Court Bar Association of Pakistan at Lahore sometime during the year 1994. Copies of that article had been made available by me to all the then honorable judges of the Supreme Court of Pakistan. Within a matter of less than 2 years of writing that article by me, the Supreme Court of Pakistan decided the famous case article on the subject had a small but a pioneering role in the end result. I would like to believe that I had been successful in sensitizing their lordships of the Supreme Court about the issue, and my little effort had at least triggered a thought process which later on led to a wonderful result. That was the first stage, the cognitive stage, wherein the issue was identified and understood and an intellectual effort was made to tackle the same. That stage has already been successfully crossed by us way back in the year 1996, although some quarters have some reservations about proper implementation and follow-up of the Supreme Court's decision in the case of Al-Jihad Trust. Now the second stage. There are so many mics on this rostrum that there's no place for me to put my file. Thank you. But media is very important. In a civilized society, and particularly in a democratic society, the significance and importance of independence of judiciary is generally understood and universally cherished. Stage 2 in the journey towards independence of judiciary is consolidation and strengthening of independence of judiciary through bringing about and reinforcing the necessary milieu for the same. It is commonly known that in order to secure and then safeguard the independence of judiciary, the following factors play an important role: constitutionally entrenched courts, security of tenure for judges, impartial appointment process, articulated judicial ethical standards, impartial discipline process, adequate and constitutionally protected salary, physical security, civil immunity for judicial functions, freedom from interference in decision-making from the superior judicial officers outside the appellate process, integration of subordinate courts as full members of the judiciary, separation of the judiciary from the executive, judicial control of its own budget, judicial control of its own administration, judicial control of the curriculum and faculty of judicial education, freedom from arbitrary geographic transfers, avoidance of retrospective legislation about anything to do with the judiciary, executive support to enforce judgments even against itself, executive support to prosecute and punish attempted or actual judicial corruption, executive restraint from interference in judicial decision-making process, an independent bar, a government sensitive to public opinion, an educated public demanding an impartial judiciary, and a free and informed print, electronic, and social media. In our quest for securing independence of judiciary, we in Pakistan are presently passing through this second stage. We are in the process of consolidating the gains achieved by us through the cognitive stage. We already score highly on many of the above-mentioned prerequisites of this stage of consolidation of independence of judiciary, but unfortunately, security of tenure and a government sensitive to public opinion happen to be two critical areas where everything achieved through the other factors stands undermined from time to time. Repeated interruptions in constitutional governance of the country with the resultant foisting of unrepresentative governments which are not sensitive to public opinion and unconstitutional and unceremonious exit of members of the superior judiciary on most of such occasions go a long way in destroying or neutralizing every other success achieved towards independence of judiciary. We are, however, keeping our fingers crossed and earnestly hope that there shall be no future military intervention in the constitutional governance of the country. Any intellectual breakthrough at the cognitive stage or any amount of consolidation of independence of judiciary through the factors relevant to the second stage is likely to be meaningless if an otherwise independent judiciary does not command confidence and respect of the people it is meant to serve. The independence of judiciary must inure to the benefit of the people at large, so that the people at large take it upon themselves to defend such independence of judiciary whenever it comes under an assault from its predators. The third stage thus pertains to developing proper perceptions about the judiciary by making the fruits of its independence available to the members of the society, and none except the judiciary itself is to reflect upon this aspect and to deliver. The people of a country may not be interested in planting and growing a tree and in making it strong if the tree bears no fruit for them and does not even provide them shade or shelter when needed. Now I come to the fourth stage, which I call the final frontier. In my capacity as a lawyer, I had written and spoken about independence of judiciary on several occasions, but when I speak now, my perspective and angle are slightly different. On the previous occasions, I had looked at the issue from the point of view of a lawyer, but this time I speak as a person who has spent about 22 years as a judge of the highest courts of the country. I have seen the system from within, and thus I know and understand a few things which an outsider may not be in a position to appreciate. In this background, I now intend to share with you some aspects of independence of judiciary which are generally overlooked, but the said aspects are so important that without attending to them, the whole superstructure of independence of judiciary remains incomplete and, if I may say so, shallow and superficial. In order to understand what I am about to say, you must appreciate that, as already alluded to earlier, independence of judiciary is not an end in itself, but it is only a means to the end. The end is impartiality, and independence only helps in securing and maintaining judicial impartiality. It is possible that a judge may be absolutely independent, but he may still be partial in many ways, and thus his independence may not be of any avail, because the end result may not be just, fair, and correct. It is some of these areas and aspects, often ignored and overlooked, which I intended to talk about and highlight today. The earlier stages that I have talked about are essentially relevant to threats to independence of judiciary from outside the judiciary. But the final frontier envisioned by me is the stage where independence of judiciary, achieved through a successful passage of the earlier stages, is to be protected from the threats originating from within the judiciary itself. Three areas appear to me to be of particular importance in this context: independence from yourself, independence from judiciary, and independence from justice. Please don't be alarmed. I proceed to explain these aspects straight away. These are new things, so please bear with me for a while and I'll explain. Independence from yourself, independence from judiciary, and independence from justice. It is generally appreciated that threats to independence of judiciary are from without, but I believe that the real threats to independence of judiciary are from within the personality of the judge himself. There are cases wherein the mettle of an individual judge is tested and tested hard, and no outside factor is available to provide him strength and fortitude. In such cases, a weak judge is likely to buckle down unless he possesses an inner strength of character, so as to overcome his personal fears and to demonstrate independence from his personal qualms and worries. There are also cases like those of terrorism or those involving extreme religious, social, or political sensitivities, wherein the judge's personal safety and safety of his immediate family is an issue, and a judge who is weak from within may find it hard to withstand the pressure. There may also be cases where a judge disagrees with the majority of his colleagues on a matter of principle, and in such matters only a judge possessing strength of character can take a stand according to his convictions. A desire to seek further elevation in his status, or even a fear of a geographic transfer to a bench of the court, may also weaken a judge's resolve to take a principled stand on issues. All such desires, fears, and apprehensions detract from a judge's independence, and notwithstanding availability of the wherewithal talked about above, the judiciary cannot become truly independent unless the individual judges are able to shun and rise above such desires, fears, or apprehensions. History is full of examples where judges with no security of tenure and lacking proper protections, immunities, or salaries had been taking bold and independent decisions. and here we have gathered for Justice Samdani, who was one of them. History is full of examples where judges with no security of tenure and lacking proper protections, immunities, or salaries had been taking bold and independent decisions. It was surely their personal mettle and commitment to their vocation rather than anything else that had made them truly independent. Let me add another dimension to this aspect by reiterating that independence of judiciary is all about perceptions of its impartiality. A judge known to be afflicted with his own personal prejudices may be independent from extraneous influences, but he cannot be perceived by the public at large as an independent judge if he does not decide his cases with an independent mind. It is universally true that every man is an island, and his approach towards others is conditioned by the circumstances of his own upbringing, his social and financial status before becoming a judge, and the cultural traditions of his own milieu. It is thus but natural that every judge tends to look at the facts of a case from his own individual perceptions, and this is why many a time different judges handling the same case and the same set of facts arrive at different conclusions on the facts. I therefore feel convinced that if the ideal of independence of judiciary is to be achieved in any meaningful manner, then a system has to be devised whereby the individual judges are trained to look at and examine the facts of a case from a standpoint which is completely divorced from the judge's own personality. I understand that in some parts of the civilized world, I'll name that civilized world, America, US. I understand that in some parts of the civilized world, despite a great fanfare about independence of judiciary, judges are selected and appointed to the hierarchy of courts, including the apex court, with particular reference to their known conservative or liberal approaches towards the national, social, or moral issues. With great respect, I consider such a practice to be nugatory to impartiality of judiciary, and I can only sympathize with the litigant taking his case to such a judge when he knows in advance that the judge openly holds and is expected to express a view other than that which the litigant is about to confess before him. A judge, howsoever independent he may otherwise be, is not independent enough if his impartiality is clouded by his personal views and perceptions. This is what I mean when I include independence from yourself as a part of Final Frontier. The second aspect of the Final Frontier that I want to talk about is independence of an individual judge from the undue pressures of his peers and from some unnecessary or unwarranted controls of his institution. There is no doubt that in his capacity as a judge, a person performing judicial functions is necessarily a part of his institution, that is, the judiciary, and ordinarily his functioning is to be in line with the overall policy and scheme of the institution. However, the problem comes when the institution's independence is itself under cloud because of extraneous factors and an individual judge starts abdicating his decision-making before the dictates of the institution, or conversely, when the institution starts excluding an individual judge from decision-making in sensitive matters because that judge is not likely to toe the line of the institution. Both such factors, which may be unthinkable in the civilized world, but may unfortunately be real possibilities in some other parts of the world, completely undermine the notions of independence of the judiciary. Apart from that, concentration of powers in the hands of the head of a judicial institution regarding constitution of benches allocation and distribution of cases amongst benches, attachment of priority to different kinds of cases, and geographic transfer of judges is an issue which has raised eyebrows in the past and can also resurface in the future. A possible misuse of such powers by the head of a judicial institution can effectively render the independence of an individual judge to be of no practical utility or benefit to the citizens at large. Such a threat to independence of judiciary has its origins within the judiciary itself, and any degree of independence of judiciary painstakingly achieved through all the other stages mentioned above can effectively be neutralized through some machinations from within the judiciary itself. In this context, I feel that independence from judiciary in the above mentioned areas may be a sine qua non for reaching the final frontier of independence of judiciary. Sir Francis Bacon, the British Lord Chancellor of his time, started his essay Of Truth with the following words, and I quote, "What is truth?" said the jesting Pilate, and did not wait for an answer. Unquote. The same can be said about justice as well. Justice is an abstract notion, and true justice can be done only if totality of the facts are known. According to the Holy Quran, when Khizr, peace be upon him, killed a minor boy for no ostensible reason, Moses, peace be upon him, found that to be unjust, and he protested against such an unjust murder. But subsequently Moses, peace be upon him, was satisfied when Khizr, peace be upon him, explained the will and wisdom of Almighty Allah in that regard on the basis of facts which were not known to human beings till then. Thus, even a prophet of Almighty Allah apparently faltered in the matter of justice on account of lack of knowledge of the totality of facts. Unfortunately, all that we fallible and mortal judges in this world have before us is a few papers containing half-truths and some self-serving statements of the parties and their partisan witnesses. Almighty Allah, the maker of us all, knows our limitations, and that is why at many places in the Holy Quran we have been ordained to decide according to the onus, quantum, and standard of proof prescribed for various offenses. In some cases, where an allegation is leveled in the absence of prescribed quantum and standard of proof, the person leveling the allegation is required to be punished, even if his allegation may in fact be true. The essence of this is that the emphasis is not upon making sure that the culprit does not go unpunished, but the focus is on punishing him only if he is proved guilty in accordance with the legal requirements. It is thus evident that we have been ordained to administer justice only in accordance with the law and not in accordance with our own subjective appreciation or understanding of what might have happened and on the basis of our own subjective sense of justice. Here I may just narrate a short story. As a judge of the High Court, a very junior judge of the High Court, I was sitting in a division bench with a senior judge who had come from the district judiciary. We were hearing a murder case, and after listening to the arguments of the lawyers, the senior judge asked me, "What do you think?" I said, on the basis of the evidence available on the record, the man has to be acquitted. There is no proof sufficient to convict him. The senior judge said, "I agree with you 100% that on the basis of this evidence he cannot be convicted." But then he said something in Punjabi. He said, "Par meri gaved kendi hai ki kita aise ne hai." Gaved, I don't know how to translate that word. It's a Punjabi word. My assessment, my experience, my understanding, my gut feeling is that he is the one who has done it. So I kept quiet. He said, I agree with you 100% that he cannot be convicted on the basis of this evidence, but मेरी गवेड़ कहती है ये कीता ऐसे नहीं है तो मैं नहीं छड़ना. This was alarming. मैं नहीं छड़ना. I was a junior judge. I was shocked that how can a senior judge even think that way? So all I could say was that, sir, I'll then write my judgment on the basis of the evidence available on the record, and you write your separate judgment on the basis of the gaved. And then what happened later on was even more discomforting. I wrote my judgment as was my practice on the same day, and next morning my judgment of about 20 pages was lying on the other judge's table for his perusal or signature, agreeing or disagreeing. The other judge had to retire after 1.5 years. For the next 1.5 years, he did not write his own separate judgment and kept the files. Because on the evidence, he could not write a judgment of conviction. He had said that, yes, I agree with you 100%. You can't convict him on the basis. So for 1.5 years, he kept the file with himself. He retired. A bench was reconstituted to hear the case. The man was acquitted straight away. So just imagine 1.5 years of that man's life in a death cell. Somebody is responsible. And on the day of judgment, maybe he will catch us from here. Okay, when both of you agreed that it was a case of acquittal, then why didn't you acquit me? Gaved. So this is what I'm talking about here. Justice. Perverted concept of justice, as if I have to do justice even if I don't know the facts. But my experience shows that he must have done it, and I'll not leave him. Let me explain this issue. In some cases where an allegation is leveled in the absence of prescribed quantum and standard of proof, the person leveling the allegation is required to be punished, even if his allegation may in fact be true. I am referring to Surah Nur, where God Almighty says कि कोई ज़िना का इल्ज़ाम लगाते हो तो 4 गवाह लाओ, 4 गवाह नहीं ला सकते तो तुम झूठे हो और अल्लाह की नज़र में भी झूठे हो. Now, if he brings 3 witnesses who are truthful witnesses, but the standard is not met, so you cannot convict even if 3 witnesses are absolutely true. This is God's standard, that if the standard of proof required is not met, you cannot convict. But God has used some words which you may please think about it at some time. God Almighty says, 4 गवाह नहीं ला सकते तो तुम झूठे हो. ये नहीं कहा कि तुम साबित नहीं कर सके. तुम झूठे हो और अल्लाह की नज़र में भी झूठे हो. अल्लाह ने तो देखा है, even if there is no witness. Something to ponder. My humble understanding is that what God Almighty is saying, that an offense is an offense only when it is proved according to the legal requirement. Otherwise, no offense is committed at all. This is something to ponder. I'm not saying that this is the interpretation that everybody should believe, but at least people should think about it. The essence of this is that the emphasis is not upon making sure that the culprit does not go unpunished, but the focus is on punishing him only if he is proven guilty in accordance with the legal requirements. It is thus evident that we have been ordained to administer justice only in accordance with the law and not in accordance with our own subjective appreciation or understanding of what might have happened and on the basis of our own subjective sense of justice. Even the Star Chambers and the Court of Equity in England had to be wound up because it was soon felt that equity had started varying with the size of the Chancellor's foot. and justice being administered was becoming more and more whimsical and subjective. It is in the background of such accumulated wisdom that the oath of office of a judge in our country requires him to dispense justice only in accordance with the law. Let me explain this issue through an example. We all know what a fake police encounter is. Jali police muqabla. We all know what a fake police encounter is. A fake police encounter is where a notorious criminal, a menace to the society, is apprehended by the police, and knowing that no sufficient evidence is available against him to prove his misdeeds before a court of law, the police officer decides to rid the society of that menace and kills that person by fabricating and faking a police encounter. The motives of such a police officer appear to be just to him, and he feels convinced that by ridding the society of that menace, he is doing a service to the society. But the law considers such a killing to be nothing but a cold-blooded murder. Please allow me to say that if a judge decides a case against a notorious person or upholds his sentence only on the basis of his own subjective sense of justice in the name of good of the society, with scant regard for the law or the standard of proof, then I see no difference between the above-mentioned police officer and the judge. A fake judicial encounter is as bad and condemnable as a fake police encounter. I strongly believe that jurisdiction conferred by law can in no circumstances be exceeded by a judge in the name of justice, because such an approach completely negates the concept of rule of law. How can a judge violating the law in the name of justice be treated more charitably than any other criminal who violates the law deliberately? Let me broach this subject from another angle. A judge is like an umpire in a game of cricket. In a tense and emotionally charged cricket match being played between India and Pakistan at Lahore, Virat Kohli hits the ball for a six, and the ball is caught by a Pakistani fielder outside the boundary rope, and the entire Pakistani team rises to its feet with an appeal to the Pakistani umpire with the question, "How is that?" According to the rules of the game, Kohli is not out, and the Pakistani umpire cannot say that although according to the rules of the game the batsman is not out, but I would give him out because it is in the interest of my country. Such a decision of the umpire, based upon a perverted and subjective sense of justice, would surely be the last decision in that gentleman's umpiring career. Like an umpire in a game of cricket, a judge's function in the justice system is to decide only and only in accordance with the law, and not according to his own subjective sense of justice or fairness. It is the law which is to take care of justice, and a judge should never try to be wiser than the law. People come to a court of law after exhausting the other avenues of justice. They want to get the legal position declared by the court, and the court should not shy away from it. In a misdirected and abstract pursuit of justice, the law is not to be relegated to the status of or condemned as mere technicalities. Such an attitude amounts to destroying the very basis and the very fabric of the entire legal and judicial system. The very purpose of having such a so-called technicalities, that is the law, is to establish an order in the society through known and codified standards. A judge ignoring the said code or the standards may be trying to do justice to one party according to his own subjective standards, which may or may not necessarily be correct and sure. But by doing that, he is throwing the entire society into chaos by violating the agreed and settled code and standards. It must never be lost sight of by a judge that he has no mandate from the society to be an apostle, a cavalier, a reformer, or a missionary. And the only mandate given to him by the society is to administer justice according to the law of the land. A judge must understand that the warrant of his appointment is not a proclamation of his coronation as a king who is above the law. Even for a king it now stands settled that howsoever high you may be, the law is above you. It is but obvious that a judge, on account of the nature of his job, is more bound to obey and follow the law than any other citizen. A judge trying to do justice by ignoring or disregarding the law does so at the peril of shaking the very foundation of the judicial system itself. As such an approach destroys certainty and predictability of judicial response. This, in turn, gradually cuts across and erodes public confidence in the judiciary, which is so important for maintaining and safeguarding its independence. The final frontier for independence of judiciary, therefore, is that the judges should shake off every other consideration from their minds and should decide the matters placed before them in accordance with the law and nothing but the law. This, I believe, is what would be the ultimate cutting edge in our quest for independence of judiciary. Thank you very much.
Justice Khosa Saab, thank you very much for a very illuminating and I must say a very insightful lecture on the independence of the judiciary. I was curious to know what the final frontier is, and I'm really glad that you've dwelled on it on the three dimensions of being independent from one's own self, being independent from the judiciary, and from being independent of one's own notions of what justice might be. I think that's an excellent segue into what I hope promises to be an interesting Q&A. So, ladies and gentlemen, the floor is open, and already I can see someone with their hand up. Please, if you would please give them the mic. Thank you.
Justice Khosa Saab, thank you. It was indeed a wonderful lecture.
May I just make a small observation?
Please.
See, I've remained a judge, and during judgeship, what we try to follow is judicial restraint. So I can know a lot of you will be interested in asking questions which may be about some judgments, which may be about the political situation or whatever. So please allow me not to answer where I think that my judicial restraint will be overstepped. Thank you.
सर आपकी जो ऑब्जर्वेशन है वो हमने सुन ली, लेकिन आई विल स्टिल आस्क यू द क्वेश्चन. यू हैव द राइट टू आंसर और नॉट टू आंसर. सिंस यू रिमेन्ड चीफ जस्टिस ऑफ पाकिस्तान, मैं आई वुड लाइक कि अगर आप उर्दू में जवाब दें तो दैट वुड बी ग्रेट. सर, जनरल ज़ियाउल हक के बाद और जनरल परवेज़ मुशर्रफ के बाद अगर किसी ने 2 प्राइम मिनिस्टर्स को घर भेजा है वर्दी के, आप वो वाहिद शख्स हैं जिन्होंने वर्दी के बगैर 2 प्राइम मिनिस्टर्स को घर भेजा है, और उसे जुडिशल कू कह लें या जो भी कह लें, एक नवाज शरीफ साहब और एक यूसुफ रज़ा गिलानी साहब, आप रिग्रेट नहीं करते कि जो कंट्रीब्यूशन आपने पाकिस्तानी पार्लियामेंट को एम्बैरस करने में और उसको कमज़ोर करने में किया है, वो आपको करना चाहिए? एक बात तो ये. दूसरी बात सर, बड़े अदब से पूछूंगा आपसे कि आपने आर्मी चीफ की एक्सटेंशन के हवाले से एक नोटिस लिया और फिर हमने देखा कि पता नहीं कोई गैर मरई और नज़र ना आने वाली कुव्वतें, शायद इंटेलिजेंस एजेंसियां या शायद फ़ौज या आई डोंट नो कौन, वो आई और फिर हमें नज़र आया कि जस्टिस खोसा जो इंसाफ के हवाले से बड़े अच्छा नाम भी है आपका, वो जाने तो लगा कि जिस तरह आपके हाथ कांप रहे हैं और आपने एक ऐसी रवायत दी, एक ऐसा रास्ता दिखाया कि मुस्तकिल एक ऐसा एक्सटेंशन का गंद इस मुल्क में पड़ गया जिसमें मैं बड़े अदब से कहूँगा शायद आपका भी कोई किरदार है, तो कोई रिग्रेट्स हैं आपको इन 2 इश्यूज़ के ऊपर या किसी और इशू पे? बहुत शुक्रिया, थैंक यू। या बल्कि मैं ये कहूँगा कोई गवेड़ तो नहीं थी इसमें।
Thank you very much.
Thank you for your question.
Both these questions pertain to my cases decided, and this is a 100-year-old tradition, not only in the subcontinent but everywhere in the world. Judges don't explain their judgments,
right,
and it is their public property. You can think whatever they are, you can deduce anything that you want to deduce, but please read those judgments. मैं आपसे अगर इस वक्त पूछूं कि हॉल में कितने लोग हैं, अगर अल्लाह को हाजिर नाज़र जान के कोई बताए कि कितने लोग हैं जिन्होंने ये पैनामा केस जजमेंट या गिलानी साहब की जजमेंट एक्चुअली पढ़ी है, तो मेरा ख्याल है हार्डली चंद लोग हैं। देखें 2 हाथ खड़े, 3। बात ये है, पढ़ लें, फिर अगर वो लॉजिक आपको अच्छा लगता है आप उसको अच्छा समझें, बुरा लगता है बुरा समझें। आई विल नॉट एक्सप्लेन 100-year-old tradition. Judges should never explain their judgment. They are written and you read them, like them, don't like them, assess them, whatever you can deduce. But I respect your views. Thank you very much.
Thank you, Khawaja Saab. And I think that's a reminder that please direct your questions to the larger topic rather than particular cases, because that simply is not fair. Please.
Sir, and moreover, I thought it was Justice Samdani's day, not my day.
That's right.
Sir, my question directly concerns with your lecture. You have quoted some insight from the Quran. I could not hear from you the basic principles of jurisprudence clearly stated in the Quran. Number 1, فَحَكُمْ بَيْنَ النَّاسِ بِالْحَقِّ, that is, pass judgment between the humankind with the truth. And the truth is evidence-based. You rightly said, sir. Second is, فَحَكُمْ بَيْنَ النَّاسِ بِالْقِسْطِ, pass judgment between the humankind with measured equity. And the third is, فَحَكُمْ بَيْنَ النَّاسِ بِالْعَدْلِ وَالْإِحْسَانِ. So, I have never seen such conduct by any judges in the whole judiciary of Pakistan. I'm 62-year-old, I'm a student of Quran and also STEM, science, technology, engineering, mathematics and philosophy. So this is my question, and this is the, you have to answer.
Khawaja Saab, if I may suggest, let's take a couple of questions. Maybe we take 3 at a time, and then you can answer the ones you feel pertinent about.
If I can directly answer, it will be convenient rather than remembering. Okay. I'm getting old now. So see, I have no claim on being a scholar of Islam. I have no claim on being a wonderful interpreter of the Quran. I'm a Muslim, I read it. Whatever little I understand, I try to practice. You have mentioned something from the Quran which says decide according to haqq. Now, at least we don't have a proper interpretation or translation as to what haqq here being referred to means. Haqq is right, if we have to decide according to the right, or maybe there's something else, I don't know. So, yes, truth and batil, al-haq, zahaq al-haqqa wa zahaq al-haqqa wa ja'al haqqa wa zahaq al-batil in al-batila kana zahuka. वो तो अलग चीज़ है ना, हक और बातिल. ये कौन से हक की बात हो रही है? मैं आपको ज़रा टोटल पिक्चर दूँगा. आपने जो अल्फाज इस्तेमाल किए हैं कुरान पाक के, हक, किस्त. अब किस्त के बहुत से अरबी में बहुत से मफ़हूम है और आम तौर पे इसको अदल के कॉन्सेप्ट में लिया जाता है. और एक इस अल्लाह ताला का ये भी है कि इन्नल्लाह युहिब्बुल मुक़सितीन, कि अल्लाह ताला इंसाफ करने या अदल करने वालों से मोहब्बत करता है. वो किस्त का कॉन्सेप्ट है. फिर आपने अदल का कॉन्सेप्ट कहा. somebody will have to interpret first कि what is exactly being talked about. Are we talking about black letter law, or are we talking about divine law? Are we talking about any social moral standards? سو ایک بات میں صرف آپ کو کامنٹ یہاں کر دوں کہ آپ نے کہا کہ عدل بالاحسان عام طور پہ جو مطلب لیا جاتا ہے، جو انگریزی کے لفظ ہے ٹیمپر جسٹس ود مرسی، یہ اس سے کنفیوز کیا جاتا ہے، حالانکہ یہ احسان مرسی والا نہیں ہے. عدل بالاحسان کا جو مجھے ناقص رائے میں سمجھ آئے وہ حسن سے ہے کہ عدل کرو خوبصورتی کے ساتھ، کہ وہی ہے کہ اٹ شوڈ بی سین ٹو بی ڈن، اٹ شوڈ بی ڈن، اٹ شوڈ بی سین ٹو بی ڈن. سو خوبصورتی ہو اس میں، یہ نہیں کہ احسان جتا کے آپ انصاف کر رہے ہیں، یہ نہیں ہے. سو ہمارے چیف جسٹس فیڈرل شریعت کورٹ موجود ہیں، بہت محترم، انتہائی قابل. تو کسی وقت آپ ان کے ٹائم لے کے ان سے یہ سمجھیں. ہی ول بی اے بیٹر پرسن ٹو کامنٹ آن دیس. تھینک یو ویری مچ.
Sir, Matiullah Jan. My name is Matiullah Jan, sir. Good to see you after a long time. Sir, بدقسمتی سے ہمارے ہاں کچھ جرنیل اور ججز جو ہیں جب ریٹائر ہو جاتے ہیں تو وہ سچ بولنا شروع ہو جاتے ہیں، اور پھر وہ کہتے ہیں ہم نے جو ماضی میں کیا وہ ہماری ڈیوٹی تھی، ہم اس پہ بات نہیں کریں گے، اور بڑی آسانی سے اپنے ماضی سے پیشہ جان چھڑا لیتے ہیں، باوجود اس کے کہ یہ ان کا وہ ماضی ہی ہوتا ہے جن کی وجہ سے وہ اس رتبے پہ پہنچتے ہیں کہ اتنے سارے لوگ اکٹھے ہو کے ان سے کچھ سننا چاہتے ہیں. وہ یہاں پہ آ کے قانون اور انصاف کا لیکچر نہیں سننا چاہتے، وہ یہاں پہ آ کے ایک ایسے شخص کو دیکھنا چاہتے ہیں جو نہ صرف
آپ تو آئے لیکچر سننے ہی ہیں.
نہیں سر، لیکن سر یہ سارا لیکچر جو ہے یہ بطور جج آپ کو یہ ساری جو فرنٹیئرز تھی اس وقت نظر آ رہی تھی جب آپ ایک وزیر اعظم کو بغیر ٹرائل کے پاناما کیس میں کنوکٹ کر رہے تھے، جب آپ وزیر اعظم کو 2 وزرائے اعظموں کو فارغ کر رہے تھے. تو سر بریف سا کامنٹ، آئی نو سر آپ جواب نہ دیں، آپ جواب نہ دیں سر. اچھا سر ایک سوال سن لیں، پھر سوال سن لیں سر. میں ایک سوال سن لیں سر، میرا سوال سن لیں. آپ اپنے فیصلوں پہ کوئی رائے نہ دیں، مگر کم از کم آپ کے سامنے ایک بہت بڑی مثال موجود ہے سابق چیف جسٹس آف پاکستان جسٹس نسیم حسن شاہ صاحب کی. ان میں کم از کم اتنی اخلاقی جرت تھی کہ انہوں نے ایک وزیر اعظم کو پھانسی لگایا اور انہوں نے تسلیم کیا کہ انہوں نے اپنی نوکری بچانے کی خاطر جو ہے وہ یہ سارے کام کیے، اور ہم دباؤ میں
جان صاحب یہ آپ پلیز ایک منٹ. نہیں دس آئی مسٹ آنسر بیکاز مائی وائف از ڈاکٹر نسیم حسن شاہ's daughter.
سر آئی ڈونٹ نو سر، میں ایک سوال کر رہا ہوں about the chief justice.
آنسر دس. آپ یہ جواب دے پروگرام جس کو آپ ذکر کر رہے ہیں نا افتخار صاحب کا، وہ آپ پلیز سن لیجئے دوبارہ سے، تاکہ یہ جو مسکنسیپشنز کریٹ کی گئی ہیں ان کے ورڈز کو ڈسٹارٹ کر کے، وہ آپ پلیز سن لیجئے، پھر آپ دیکھیے گا کیا یہ آپ کا سوال جائز ہے. تھینک یو. یہ ہرگز یہ بات نہیں کہی. تھینک یو.
جی یس پلیز، آئی ہیو اے کوسچن ایٹ دا بیک پلیز. Can someone give the mic to at the back? Just 1 second.
Sir, in the brief clip we saw regarding Justice Samdani, we saw his views on oaths, and I also happened to just quickly go through his essay, chapter 5 of the book, which is on General Ziaul Haq's martial law. Given his very unequivocal stance on oaths, what are your views on the oaths taken in 1999?
See, societies evolve. People learn. People commit mistakes. Things started in 1981 when Justice Samdani was there, and all the later ones were not even on the field, on the scene at that time. People learned through their experiences, and gradually this non-acceptance of a military oath gained currency. People thought the benefits of it, their commitment to the society, commitment to the constitution were gradually highlighted. Societies evolve, and 80, 99, 2001, then 2007, and all these stages, people have evolved, societies have evolved. So kindly understand it in that context. Don't start blaming those of 81 while comparing them with those in 2007 or vice versa. People have learnt lessons and people have made amends.
So, but would you agree that 99 was a mistake?
If that is what you are pointing out.
But was 99 a mistake then, if I'm understanding you correctly?
I don't want to say anything on that issue at the moment. Thank you.
Thank you. The floor is open.
But what happened in 2007 was certainly amends. All there was a mistake. If at all there was a mistake, then a proper reparation was made through giving a sacrifice. Thank you. Thank you very much.
Thank you. We can take one final question if there is one. Yes, but please, if I can request you, we are interested in a discussion on the institution of the judiciary and not on individual cases or on political point scoring. If you can keep that in mind, your question is allowed.
समदानी साहब की यहाँ पे जो वीडियो चला रहे थे उसमें वो कह रहे थे कि जिस जज ने पीसीओ के तहत हलफ लिया मैं उसको जज नहीं समझता। तो खोसा साहब ने 2007 में तो इनकार किया परवेज़ मुशर्रफ को, लेकिन उससे पहले जब 1998 में गालिबन जज बने थे तो पीसीओ के तहत हल्फ लिया था। तो क्या उस पर कोई अफसोस है कि पहले नहीं लिया हल्फ, पीसीओ का हल्फ लिया और बाद में इनकार किया?
Thank you. It was not meant to be. And why am I being kindly talk about Samdani Sahab? If you want to hear some good things about me also, then many of these people may be very kind. So, sir, I want to add a few things.
Sure, please, go ahead.
What my experience is that all the judges are generally very decent people, very honest people, and they want to decide correctly, they want to be fair to all. But it's that inner strength which sometimes detracts them from taking the final plunge or giving a very hard decision. So that fear of annoying others is something which is relevant. And for regarding that, fear of making enemies, powerful enemies, that is something which was talked about by Charles Mackay. He was a 19th century Scottish poet, and he had said something which is quite relevant. And if you permit me,
sure,
I'll just read. He says, "You have no enemies, you say? Alas, my friend, the boast is poor. He who has mingled in the fray of duty, that the brave endure, must have made foes. If you have none, small is the work that you have done. You have hit no traitor on the hip. You have dashed no cup from the perjured lip. You have never turned the wrong to right. You have been a coward in the fight." So, when you live live through a judicial career of 22 years like I did, there will be many people who will be angry at you. So this is what Charles Mackay had said about them, that you will make enemies, you will make foes, you will step on people's toes, and they will come back to you, they will haunt you, but in the fray of duty, you have to do it. And then the last thing, for today's meeting, and Amida Riaz, which I read at the end of my reference speech, the last words on the bench, as my reference was a Supreme Court reference, and I was the last to speak, and these were my last words. Fahmida Riaz has a poem called Faiz Kehte, and the poem is short and I'll read it. कुछ लोग तुम्हें समझाएंगे, वो तुमको खौफ दिलाएंगे, जो है वो भी खो सकता है, इस राह में राहज़न हैं इतने, कुछ और यहाँ हो सकता है, कुछ और तो अक्सर होता है, पर तुम जिस लम्हे में ज़िंदा हो, ये लम्हा तुमसे ज़िंदा है, ये वक्त नहीं फिर आएगा, तुम अपनी करनी कर गुज़रो, जो होगा देखा जाएगा.
Sir, thank you very much, sir. On these,
sir, एक question है बाबर अब्बास.
No more questions. Thank you very much.
Sir, आज़ाद अदलिया से
Thank you very much. No more questions. I'm the moderator. You're not. I'm saying no more questions. Thank you very much. Khosa Saab, thank you so much for summarizing and recording those couplets, because I think it is the reality that any of us, whether you're a civil servant, whether you're a judge, when you do your job, and if you do your job properly, you're not going to make everybody happy. That's a part of life. And I take away from your paper, sir, especially I liked your point number 2, dimension number 2, that a judge has to be independent of the judiciary itself. I say that because there are many institutional issues which the judiciary needs to free itself from. And independence, while it is extremely desirable, as you say, is not an end in itself. Independence is there for the larger purpose of impartiality and delivering justice. And therefore, when we see that independence is used as a shield to prevent accountability, and my favorite exhibit number 1, if you like, on that is that we've not had audit of the superior courts for decades in this country. Courts use public money, and there should be audits, and sadly there are no audits. So I think there are instances when independence can be used as a shield to accountability, and I think you've given us a very good reminder that indeed that if we want to have true independence, then independence means that independence of some of the institutional constraints which the judiciary imposes on itself and its own members. Those are things we have to get across as well. Thank you very much again, and I would like the organizers to really polish up with your help your lecture, and we will inshallah publish it, because I think it is worth publishing, is worth distributing much more widely. Let me, on those words, thank the Chief Justice of the Federal Shariat Court, Justice Chauhan, who has graced us, many senior civil servants in the audience who have graced the occasion today, many lawyers, dignitaries, ladies and gentlemen. Thank you very much for your presence. And on behalf of the organizers, I would again like to thank you and to show our appreciation of this. I would like to thank all those who have been organized, who helped us to organize this, starting from Qureshi, Samdani and Qureshi firm, the Safer Communities Foundation, hotel staff here, and many others who have been associated in arranging this function at a very short notice, because we wanted to catch 13th of May, which is the birthday of Justice Samdani. So with those closing remarks, may I invite Soeb Shadal Saab, sir, to present to you our token, and Barrister Farooq Qureshi to present to you a token of thanks. Sir. Ladies and gentlemen, refreshments are served at the back, so see you there and mingle. Hope to see you soon. Thank you. Long time no see. How are you? I saw them you right. Good. Good to see you.
Went wonderfully well.
Thank you.
Mashallah, it's, I hope this is going to be an annual feature.
Yeah, we want to make it an annual feature.
It must be.
You can sponsor it next
year. Such a dearth of these sort of things. They got the best to invite the media next time. They just have their own. आपने एक सवाल कर लिया चुप कर दिया तकलीफ तो ना करे ना एक लाइन बोले मर्जी है जवाब देना